Hello, everyone. We're going to get started today. My name is Kelly Mylink. I am a member of Husch Blackwell's immigration team. We are excited to be talking to you today about the healthcare industry and immigration, shifting policies and compliance issues you need to know. Before we really get started, I would like to cover a few housekeeping items. So at the bottom of your audience console, there will be multiple application icons for your use during our program today. And I want to take a minute to just highlight a few of the key icons for you. If you do have any questions during the webcast, you can submit your question via the question box. We will try to answer all of those questions during the webcast today, but if a fuller answer is needed or we run out of time and just can't get to those questions, we'll answer those later via email. So we do appreciate your audience participation. We encourage you to submit your questions, and we'll try to get to them, but we just may not. There also is an icon to assist you with your viewing preferences. So accordingly, just note that you can expand your slide area by clicking on the maximize icon on the top right of the slide area, or you can drag the bottom right corner of the slide area. If you have any technical difficulties, please click on the help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck and additional materials are available in the resource list icon that looks like a folder at the bottom of your screen. This program has been approved for continuing legal education credit in Illinois, Iowa, Missouri, Nebraska, Tennessee, and Texas. Wisconsin credit is currently pending. To report your hours in Illinois, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. Additionally, this program is also approved for HRCI and SHRM credit. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. So joining me today is my colleague, Christine Fabin. She's also a member of our immigration team. And we are going to be sort of switching off here a little bit. I'm going to get us started today, and then Christine will sort of take over on a couple of the other topics. But we do have a lot to talk about here. When we were trying to think about all of the changes in the immigration industry, we came up with a whole host of topics, and then we ended up including them all in this webinar. So we won't get far in depth into a lot of the topics that we plan on covering today, but if you have questions about them or there's a topic that you'd like us to go a little bit more in depth into, let us know, and we will be sure to take into consideration your comments so that we can prepare for future webinars as well. So today, we are going to try to cover 4 big topics here. The first is immigration enforcement actions in the healthcare setting. And that's really some of the things you've been seeing about in the news and reading about in the news. So try to kind of talk about our experiences in this area. We're also going to talk about immigrant access to healthcare. We're going to go over that pretty briefly. I mean, there are a lot of issues there, but we want to sort of clarify some of the issues that you might have been reading about or seeing in the news as well. Then we're going to sort of shift gears, and Christine is going to talk to us about some of the policy changes affecting the sponsorship of your foreign national healthcare workers. So if you're an organization that's sponsoring individuals or employees for work authorization, through the H-1B process or some of the other immigration visa categories, we're going to talk about some of the changes. And then Christine is going to put on she's going to get out her crystal ball and forecast immigration policy changes that might be impacting the industry in the future. So sort of what might be coming down in the future that we might see and might be affecting us. So here we go. We're going to start by talking about immigration enforcement actions. And really, ultimately, I want to put a caveat to this before we even get started here, and that A lot of these immigration enforcement actions, we're going to talk about them from an immigration perspective. We are immigration attorneys, but in a lot of these actions that take place in different settings or at different organizations involve a lot of different attorneys. So sometimes we have to get a healthcare regulatory attorney involved. If it involves an employee, sometimes we need to consult with an employment lawyer. So there are all sorts of types of expertise and issues that can go on in these immigration enforcement actions that require, a lot of, just a lot of experts in the room. And so I want to put that caveat in that we're coming at this from an immigration law perspective, but certainly there are a lot of complicated issues in these types of immigration enforcement actions that require a lot of minds to really be thinking about all of the issues. When we're talking about immigration enforcement, I usually start this topic by going over the different government agencies involved in immigration. There are three main agencies that are involved. One is the Department of State. The Department of State oversees all of the consulates outside of the United States. So if somebody is applying for a visa to come to the United States and they apply for that visa at a consulate outside of the United States, that's all operated by the Department of State. Those officers are Department of State officers. They are subject, of course, to the same immigration laws, but they have their own policies and guidance guiding those officers at those consulates. The other agency that's sort of tangentially involved is the Department of Labor. The Department of Labor only really gets involved to the extent you are an organization that's sponsoring foreign national workers for work authorization through the H-1B program, for example. The Department of Labor wants to make sure that any employer is paying the wages to the foreign national worker that are on the same playing field or level as your U.S. workers, that the working conditions are the same as U.S. workers. In terms of the permanent resident sponsorship, you're going through the appropriate processes in the permanent resident sponsorship cases. So they're sort of involved in some immigration cases, not all of them, but they can be. So we put them on this list. The big agency involved, of course, is the Department of Homeland Security. The Department of Homeland Security has several offices that are under it, including U.S. Customs and Border Protection. Those are the officers who are at the border. So CBP, Customs and Border Protection, those officers are ensuring that individuals who may have a visa now, when they come to the border or they arrive at the airport, they are admissible into the United States and they have the appropriate documentation to come to the United States. So they are sort of the border enforcers. U.S. Citizenship and Immigration Services, or USCIS as we often call them, that agency is adjudicating visa petitions inside of the United States. So if you have sponsored someone, if you're an organization that has sponsored someone for an H-1B visa, for example, USCIS is, of course, the agency that adjudicates those immigration petitions. So they do have some enforcement power. There is a fraud unit within USCIS that does conduct worksite inspections and fraud investigations. So if you, going back to the H-1B example, if your organization sponsors H-1B workers, there's always the possibility that a USCIS officer could show up at your door to ask about the H-1B worker and ask about the terms and conditions of their employment. So they do have sort of a mechanism or an office within USCIS that does conduct some immigration-related investigations. The largest arm here, though, in terms of enforcement is, of course, ICE, or U.S. Immigration and Customs Enforcement. ICE is the agency that is responsible primarily for enforcing immigration laws within the United States. They are the officers that detain or prosecute or remove foreign nationals from the United States who are in violation of the immigration laws. They also have a wider umbrella. They conduct Form I-9 audits, and they are penalizing employers for non-compliance with the Form I-9 rules. So The Form I-9 is the form that every employer has to fill out for every new employee regarding an employee's work authorization and identity documentation, so verifying that the person is who they say they are and that they have the appropriate documentation of their identity and work authorization. And ICE also administers the F1 student and J1 exchange visitor program. So I know in the healthcare context, a lot of physicians are in J1 status. ICE is the agency that oversees that program, as well as for university individuals who are at universities or colleges who might be sponsoring F1 students. ICE is the agency responsible for the sponsorship of F1 students as well. But what we're going to focus on is sort of the role of ICE when they come into a healthcare setting. So if you've been reading the news at all, you have been flooded with headlines about this. ICE officers coming into hospitals to initiate an enforcement action over a patient who's about to go into surgery. ICE is stopping an ambulance on the way to the hospital. There's all sorts of headlines out there about what ICE is doing, and while it might be an isolated context, I mean, as we know, these stories are sort of out there and you hear about them, and it's good to know sort of what's going on. From our perspective, you know, what we're here to do is sort of tell you about our experiences and tell you about best practices, but the best thing that you can do is to share experiences with your colleagues, to share experiences with us too, because we want to know what's going on. Has an ICE officer visited your organization? In what context did they do that? You know, a lot of times how we react and how we respond and our best practices are developed through these types of experiences that we share with one another. So getting that information and sharing it to help any organization develop those best practices for how to handle these situations. One, to make sure it doesn't disrupt your organization, disrupt your workforce, and you know, disrupt the daily activities that you are trying to accomplish as an organization, while also making sure that you're staying in compliance with all of the relevant laws in terms of immigration, and then also any relevant laws that you are subject to as an employer or as a healthcare facility. Overseeing all of this is this ICE-sensitive locations memo. As you've heard me talk about enforcement in the past, this is one of the things we often start with, is that there's this sensitive locations memo out there from 2011 that still exists, which it only lists hospitals, but it does generally, I think, most ICE will include healthcare facilities in this sensitive locations memo, that these are places where ICE enforcement actions should be limited. ICE officers should take pause before conducting any sort of action, arresting somebody, raiding a place that is on this list. Hospitals are on the list, schools, of course, churches. They're just places where, you know, it's more sensitive, for lack of a better word, right? Unless this memo has certain exceptions. So unless exigent circumstances exist, or they have approval from a certain designated agent in their office. So really there are a lot of exceptions here. Like I said, this memo is still in place, but my experience is, yes, ICE does take into consideration that hospitals and other healthcare facilities are sensitive locations, but you know, if they have to enforce an action, it doesn't take them long to, you know, call up their superior and say, hey, this is the deal. We need to go into this area to arrest a person. We've got the warrant. Can you sign off on us doing this? And generally, if they'll do so. So while it's out there, how effective it is kind of in question. And really, it doesn't have much bite to it. It's just a memo. It's not a law. Generally, if an ICE officer is coming to an organization, a hospital or other healthcare facility, they're asking to do two things, right? They might be asking for documents or information, or they might be coming to actually arrest a person. And in terms of requesting documents or information, Usually, and when I see this in the healthcare context, they might be asking for information about a patient. Sometimes they're asking information about a patient's parents. Somebody who took the person to the hospital. They are sort of, found out because it was a traffic accident or something like that, and then ICE came to be aware of the situation, realized that one of the persons was not following the immigration rules or subject to removal, and they were going to connect action, and they wanted some information. So these can happen, although less common in the healthcare context where they're requesting documentation. ICE sometimes, in terms of an employee, will come in and ask for an employee's I-9 documentation or their employment records. So this is if they have sort of a case ongoing against someone and they want to see that person's I-9 records. What did they write on their I-9s? Did they use somebody else's identity? They might be asking for a person's I-9. Generally, though, ICE is going to need a subpoena or a search warrant to request documents and information. But importantly in all of this, and it's important to remember that a hospital or a healthcare facility or any employer or organization is never under any legal obligation to disclose a patient or employee's immigration status. So, if they're just asking for information about a patient's immigration status, that's information that you're not required to share. And of course, then, there are also HIPAA considerations in here too that you have to consider when ICE is asking for information or documents regarding a patient particularly. But generally, they're going to need to present some sort of subpoena or search warrant. In terms of your best practices, you want to make sure that when you get one of these subpoena or search warrants, you want to notify and consult with an experienced attorney, somebody who knows how to read those and who knows what to do when it happens. And you want to make sure that you actually have a copy of it and that you're reviewing it to make sure that it has the appropriate request in it. Does it say the location to be searched? Does it specifically say what documents that they're looking for? Address, time and place, is it signed? All of these things are very important in terms of looking over a subpoena or a search warrant. And then, making a copy of that and then making sure that you don't provide more information that's requested. But generally, the bigger, more sensationalized issue in terms of the healthcare context is when ICE is coming to visit, or ICE is visiting a healthcare facility or a hospital to actually arrest a person, to carry out, an arrest. In these cases, ICE will present a search warrant or arrest warrant, and they have to. Sometimes, in my experience, they will come and just ask or tell you that they are going to arrest a person. And in those instances, my recommendation is to say, hey, come back with the appropriate warrant. You need a warrant to effect that action here. And they will. They will come back within a matter of hours, it's not days, with the appropriate documentation to do so. The same goes with if they present a warrant that's deficient. And you say, oh, well, it looks like you're missing the date on this warrant, or this doesn't look like it was signed by a judge. They're going to go back and get the appropriate documentation, and they're going to come back. One of the things that I've noticed about ICE in my recent experiences is that when they do come back, they're not going to tell you when they do. They're going to come back when they have the documents, and sometimes that's at 3 in the morning. They know when, people, the regular officers or administrators of certain organizations are not going to be there, and they will come at 3 in the morning to effect that arrest. So in terms of ICE, you can always say, hey, we understand that you have a warrant here, but it's deficient, and you can buy yourself some time, but usually it's a matter of hours, and it's important to know that they will come in the middle of the night to effect these arrests. They'll come in the middle of the day too, but it's happened in the past where they'll come in the middle of the night. But the best practices here are the same. You want to look at that arrest warrant. If you can possibly bring the person to the officer that they're trying to arrest, it's better to do that. That's just a disruption issue, right? These issues in terms of when ICE is on a premises, it's always sort of this heightened anxiety. So, you want to work with the officer to see if there's a way that you can lessen the disruption to your organization. And then making sure that if the officer has that appropriate search or arrest warrant, that you're accompanying them at all times while they're on your premises. Just the search warrant to arrest a person is just if the officer has to go into a private place. If a person is in a public place, such as a waiting room or a lobby that's open to the public, the officers can arrest somebody in a public area. If there is a more private area, then the officer has to have that search warrant to get into that area that's private. So keeping in mind that public and private distinction is really important, because in order to go to a private area, the officer does need to have a search warrant. So this is just some information about the public and private areas, but I'm going to just skip past that to talk about best practices. So there is a lot of implications in terms of ICE being on a premises, particularly a healthcare facility. And as I mentioned before, the best practices is you need all the minds in the room that you can that might have expertise on this issue. I mean, particularly, you need somebody with immigration expertise. You need somebody who understands the healthcare regulations involved. If there are any HIPAA concerns with release because they've asked for information about a patient, all of that expertise is important that you consult with those appropriate people. But generally, my recommendation in terms of preparing for this, if your organization says, you know what, we need to have something in place so that we know how to handle this, is really to start by just having sort of a cheat sheet at the front desk or whoever is sort of the frontline person. And that person has all of the designated contact information for the appropriate people, for counsel, for any higher level executives or administrators that need to be contacted. And then a simple set of procedures. Things like, hey, have the officer ask the officer to just take a seat while you read over the documentation that they presented. Make sure you get a copy of the officer's contact information, their business card. And making sure that the person is accompanying the officer if the officer has to effect that action right away. So having sort of that checklist so that the person who's going to be the first person to encounter these officers knows what to do and knows who to call. That's usually the first thing to do. You'll see articles about, having sort of drills, but honestly, I mean, the best thing you can do is to make sure that whoever is going to encounter these officers knows who to call and that those persons are available to answer those questions and to handle that situation right away.
Kelly, I have a quick question.
Yep.
Usually when ICE is showing up, what type of foreign nationals are they looking for? I mean, is it anyone that's here on a visa? Do they have to not be on it? I mean, what's the common pattern that we see?
Yeah, so Christine asked a good question. They are looking for anyone who has violated the immigration laws and are subject to removal from the United States, deportation. It used to be where there's a priority of individuals that ICE was really looking for. So ICE would say, you know what, we're only looking for people who are, have certain crimes that are considered more severe than maybe driving without a license. But those priorities under this administration have really gone away. If somebody has violated the immigration laws and if they are subject to removal or deportation, ICE has put them all as a priority and will conduct enforcement actions or arrest any of those individuals. Great. So it's really anyone who's violated the immigration laws. Particularly, you're going to be looking, it'll be those who are undocumented, really. Which brings us to immigrant access to health care. I'm going to cover this issue so briefly because there are a lot of layers to this, but it has been in the news lately, so I think it's something that is good to know because the information out there really boils down to one part of immigration law that I want to talk to you all about today. But why this is an issue is because you have a lot of undocumented immigrants, people who are here and they don't have immigration status, who are uninsured. I think the number of non-elderly is up to 46%, and that was back in 2017, who are uninsured, which is a large proportion of individuals when you think about, I think 2017 there might have been, the numbers were like 10.7 million individuals who are undocumented in the United States. That's a large percentage of people who just don't have insurance and really can't get it. So that, when you're talking about the entire population, of U.S. citizens who are uninsured, that number, of course, just as a number is going to be higher, but the percentage is higher of those undocumented immigrants who are uninsured. Generally, undocumented immigrants are not going to be eligible for a lot of your main programs, Medicare. They can't enroll in Medicare or enroll in Medicaid, the Children's Health Insurance Program, and they can't purchase insurance through the ACA marketplace. There are some states that have, and this excludes, I guess I should say, this excludes your emergency care. But there are some states who have extended CHIP coverage to protect or to provide prenatal care to undocumented mothers, because the idea is they're having a child, and when that child is born, they will be a U.S. citizen, so it's really protecting the child. That's the rationale there. I'm going to flip ahead just to another slide really quickly. The ACA marketplace is lawfully present immigrants, so people who have immigration status in the United States are eligible to purchase insurance through the ACA marketplace. But those individuals who are eligible for DACA, or Deferred Action for Childhood Arrivals, these are the individuals who are not considered lawfully present. They are protected from deportation is the best way to describe it. They're protected from deportation, but when they are not considered lawfully present, so they cannot purchase through the marketplace. They could go out there on private, and purchase insurance privately, but not through the ACA marketplace. Medicaid and Medicare, generally, there are a lot of caveats to the Medicaid and Medicare programs, but you generally must be lawfully present for 5 years. So somebody who has immigration status in the United States for 5 years before they're eligible to enroll. There are caveats to that, emergency medical care being one of them, and certainly I would direct you to Medicaid.gov, which has a beautiful presentation or pamphlet on essentially non-citizen eligibility for Medicaid, which really sort of summarizes this in very nice fashion. So I would direct you to Medicaid.gov, which is really great information there. There's also a state-by-state analysis to consider. Some states offer coverage to undocumented children and pregnant women, as I said before. And then California has just passed a law to become the first state to provide health benefits for young, low-income undocumented immigrants through the Medicare program. In all of this, the thing that all of these individuals are considering before they're enrolling in these programs, assuming that they're eligible, is that there is a rule that states that foreign nationals might be denied permanent residence, which is a green card, or a visa to enter the United States if they are considered likely to become a public charge. This is sort of this totality of the circumstances where we're looking at a bunch of different factors to determine whether somebody is going to become dependent on public benefits. So things like age, health, family status, their financial resources, but also their enrollment in certain programs. So if somebody is enrolled in long-term institutional care under Medicaid and SSI, temporary assistance for needy families, state and local cash assistance programs, enrollment in those types of programs is considered part of this determination that might result in somebody being denied permanent residence because they've enrolled in these programs. There are certain programs that are excluded under what was the current law, Children's Health Insurance Program, Medicaid, and other non-cash programs. Well, just recently, there were some new regulations issued related to this public charge rule. So this new rule considers a foreign national a public charge if the person receives a public benefit for more than 12 months out of 36 months. And how that 12 months is calculated is very complicated too. For example, I believe if you take 2 of these benefits in a 1-month period, it ends up counting for 2 months. is how it reads. So there's a lot of, there's a little bit of confusion about how that's calculated, but generally, taking any type of assistance that's on these list of what would be considered a public benefit could result in a denial of permanent residence or a denial from a visa from a consulate. So there are a host of programs now that are included on this public benefit list that might preclude somebody from obtaining permanent residence. And I'm not going to go through them. They're all on your screen. There's a lot of exceptions. So Medicaid's on the list with the exceptions for things like emergency medical conditions, individuals who are under the age of 21, pregnant women. So there's all sorts of exceptions here, but generally this has become sort of this issue about how to advise individuals who are seeking permanent residence, who have that avenue, about whether or not they should enroll in programs that they are eligible for. So a lot of these individuals might be eligible for programs but aren't necessarily able to or may not necessarily want to enroll in them because it will preclude them in the future. This has caused a whole host of debates on various sides. I'm not going to get into that today, but certainly if you are counseling undocumented immigrants or just immigrants generally, I have come across a lot of situations where social workers will say, oh yeah, you qualify, you should enroll in this. And then all of a sudden that becomes an immigration issue for that individual later on. So the reason this is important is because, it's even if they are eligible for the programs, it might become a problem in the future.
I have a couple questions for you, Kelly.
Oh, no, I don't want to answer that, Christine.
Okay, so for foreign nationals who are wanting to get health insurance through their employers, do they have to have a Social Security number?
Yes, they do. And foreign nationals who are eligible to work will be able to get a Social Security number. It might take them a couple weeks to get it if they've just arrived in the United States, but they're all eligible to get a Social Security number, and they're able to get one and should have one once it takes a couple of weeks, but they should be able to get it.
Awesome. And then what about advice for employers that are wanting to call ICE on a patient? Do you have any advice for these employers?
So I guess the first thing is to understand to talk about the healthcare HIPAA implications. Is there going to be a HIPAA implication? And I'm not the expert to answer that question. But certainly there are avenues to do so, and some organizations do call immigration or ICE when they find out a person is undocumented or a patient is.
So case by case, that's what it sounds like.
Really a case by case scenario.
Awesome.
Well, Christine, I think I'm done answering your question. I'm going to throw this over to you to talk about sponsorship of foreign national workers.
Awesome. So before I get started, though, one final question. What did the optometrist say to the patient with 3 eyes?
I don't know.
Aye.
Oh, no.
Sorry, I had to. It was too easy.
This is what happens when I tell Christine that she can make jokes during the webinar.
Great. Thanks, Kelly, so much. That was awesome and super helpful. And thank you all for listening in with us today. As Kelly mentioned initially, this is going to be pretty high level. There has been a lot that has happened in the past couple of years, and it would probably take us an hour to get through any given bullet point. So feel free to submit questions as they come up, and we're happy to chat through them. So let's jump right into policy changes affecting sponsorship of foreign national healthcare workers. Before we get into the nitty-gritty, I just wanted to quickly touch base on foreign nationals in the healthcare industry. If you are in healthcare, you know that foreign nationals are a huge part of driving the healthcare industry in the U.S. Recent studies suggest that 1 in 6 U.S. healthcare workers are immigrants, and here's a quick breakdown. So nearly a quarter of dentists, a fifth of pharmacists, and a third of physicians are born abroad. So in total, about 26 million or 17% of healthcare workers are foreign nationals. Here are some more number breakdowns. Of those specialties, about 28% of physicians and surgeons are foreign nationals, and 24% are nursing, psychiatric, and home health aides. So I'm really giving you these numbers to just highlight the role that immigrants play in U.S. healthcare. The United States healthcare industry really relies on the foreign national workforce, and our foreign national workforce helps us, provide high quality and accessible patient care. I also am providing you these numbers because I want to additionally highlight that really any policy changes in employment-based immigration means policy changes that affect the healthcare industry. So how have these policy changes in the past couple of years affected healthcare workers? I think the best place to start this conversation is by looking at Buy American and Hire American. So in 2017, Buy American and Hire American, or BAHA, was signed by President Trump. When BAHA was first signed, most of us really thought that the likelihood of immediate change to the employment-based immigration system would be minimal. The immigration system is large and it's complicated and it moves very, very slow. Almost 2.5 years later, I can confirm that we were all completely wrong. This executive order has really changed the immigration landscape with the alleged intent to restrict legal immigration for the purpose of protecting U.S. workers. On paper, BAHA might sound okay. However, the rationale behind BAHA doesn't really make much sense in a full employment economy when the healthcare industry is really hurting because they can't hire enough workers and they can't hire or are having trouble hiring foreign nationals. So with BAHA, we really see the implications of the policies of BAHA come to surface with 3 of the primary agencies that we work with. And I'll kind of walk you through each of these agencies, but we'll look at BAHA with U.S. Citizenship and Immigration Services, the Department of State, and with U.S. Customs and Border Protection. So with USCIS, one of the first changes we saw that happened under BAHA was the rescinding of the deference memo. The deference memo was really important because historically, the deference memo allowed USCIS to give deference to prior approved petitions so long as the petition involved very similar facts. So, for example, we have dentist Joe, and he works at Blackacre Clinic on an H-1B. His first H-1B has been approved for Blackacre Clinic, and the clinic is now going to renew his H-1B visa. Traditionally, what would have happened is that it would have been a slam dunk petition, and USCIS would have given deference to the fact that he had an approved petition that sat within immigration. Now, when immigration gets dentist Joe's renewal, immigration will take a brand new look at the case as if they'd never seen it before. So this is huge, and now that this deference is no longer applicable, adjudicators are issuing an unprecedented amount of requests for evidence. For those of you who are new to immigration, an RFE, or a request for evidence, is basically a request issued by immigration when immigration believes that they need more evidence to process a case. In my opinion, they are often issued very unnecessarily, and they cause a lot of uncertainty and havoc for both our healthcare client companies and their employees. As you can see from the slide, since the signing of BAHA, there's been a dramatic increase in both RFEs and in denials. So the third thing I wanted to quickly touch base on is this multiple worksite location. We're seeing immigration take issue with our healthcare workers who are working at multiple locations. This comes up a lot with our healthcare aides and our doctors who work out of multiple offices or hospitals. Immigration in these multiple worksite locations are, they're wanting itineraries, and these itineraries usually have to be pretty long and detailed and should be really able to pinpoint where the foreign national will be working on any given day and time in a year or the 3 years if we're doing an H-1B. They've proven to be frustrating for many of our healthcare client companies, but, not insurmountable. So a couple more things with USCIS. Processing times have skyrocketed under BAHA. Thankfully, many of our visa options, our J-1 Conrad waivers, our H-1Bs are still available, but given the amount of time it takes to prepare these petitions up front and then how long immigration is taking once they get their hands on them to process the petitions, I really encourage each of you to be looking at these cases early and often and to be having these active conversations with your foreign nationals and with immigration counsel so that we can all avoid any surprises. And then finally, I just wanted to do a quick blurb on students. If you employ F1 OPT STEM students, you should be preparing yourselves for an I-983 audit. DHS is conducting on-site inspections. We've been seeing more and more of them over the past couple of months. So just a heads up and be aware. All right, so if that wasn't enough for you, we're also seeing significant changes with regards to how the U.S. Department of State is processing our visas. So as Kelly mentioned before, all of our consulates and embassies kind of sit under the umbrella of the U.S. Department of State. We're seeing instances where healthcare workers are receiving approvals, yay, from USCIS. So, Dentist Joe gets his petition approved, but when it comes time for Dentist Joe to travel abroad and get a visa stamp in his passport, the consular officers are basically re-adjudicating the petition and denying or sometimes delaying issuance of the visa stamp. This really differs from consulate to consulate, which is frustrating, and sometimes some consular shopping has to take place. Again, thankfully, we're getting our visas approved. However, when it comes to travel, and I would say especially to India or China, it's really important that we understand under BAHA, denial or delay is a real possibility. I would really encourage you to make sure that your healthcare workers are adequately prepared and prepped for their consular interviews. Good preparation is going to really help with avoiding unnecessary problems at the consulates. So we've gotten our petition approved with the USCIS, wonderful. The consulates have given us our visa stamp, awesome. But now we have to get through U.S. Customs and Border Protection. At CBP, we have been seeing our foreign nationals turned away or having to undergo additional secondary screening, which can sometimes take hours. Especially for our TNs, which include our nurses from Canada and Mexico, or any other medical professional covered by the NAFTA agreement, we're just having a lot more difficulty at the border and seeing a lot of intense questioning by CBP as to why a U.S. worker cannot do the job that the foreign national is entering to perform. Again, this is like quintessential BAHA. Please make sure that your healthcare workers have adequate documentation and a good employer support letter for their port of entry crossing. It's really frustrating when, you know, we've gotten the visa approved with the USCIS and we've gotten the stamp from the consulate, but then we get to CBP and CBP says no. So anyway.
I have a question.
Yeah.
Okay, Christine. So I heard that the Customs and Border Protection agencies are searching people's cell phones. Is that true?
Mm-hmm. Yes, it is true. Yeah, we need to make sure, and I mean, I don't know, I think this goes into the preparation that's given to foreign nationals when we know that they're going to be traveling abroad. CBP is basically wanting phones, and they're wanting phones unlocked, and they're wanting to look through social media, emails. So, yes, it is true. And my understanding is that the consulates are also doing the same thing, where they're, you know, really taking advantage of social media and pulling whatever they can up.
What happens if, you know, I wouldn't do this, but let's say there was a photo of my friend and I, and my friend was, you know, smoking something they shouldn't have been smoking. Could that affect my chances of getting in if I was a foreign national?
Guilty by association, yes, absolutely. So immigration right now is, the government right now is doing everything they can to reduce the immigrant flow into the U.S. So really anything that comes up in social media, on a phone, in the petition or application process that immigration doesn't like, they can simply deny entry.
And I think by doesn't like, it really is, that might mean that that person would be inadmissible because they have done something in their past that would fall under the laws that says they are inadmissible into the United States. So certain things, like if you have committed a crime in the past and there might be some evidence that you did something that you should not have done, right, or that you were not arrested for, right, immigration can still say, hey, sorry, we're not letting you in.
Or you were associated with someone who did a crime in the past, right? Yeah, so, I mean, all that to be said, things have been a little upside down in the immigration environment. All of these issues we discussed, they're not insurmountable. You know, we've had a lot of success. However, I would stress that the immigration environment is just completely different than it was 2 years ago, and there needs to be a lot of thought and preparation and solid strategy if you're going to be employing and sponsoring foreign national workers. All right, so now that we've gotten that done and out of the way, let's look at a few policy changes we expect to be coming down the pipeline. Again, you know, these are not for sure things, but we kind of want to tell you about the whispers that we're hearing, and really focus on continued reduction of immigration without changing the law. Because a lot of what we've seen the past couple of years is the change to immigration through policy. We have a colleague that says policy change by denial. So we know that the way that immigration is processing things is different based on a policy, and oftentimes we only know that policy is in place because we start getting RFEs or denials. So 3 quick things. I know we're running out of time. The first one is the elimination of employment authorization for H-4 spouses. The H-4 Employment Authorization, or EAD, has been around since 2015. It basically gives spouses of H-1B workers who are waiting for a green card to become available permission to work. This has been a real saving grace for a lot of our foreign national employees who are here on H-1. The current administration is in the process of trying to revoke the work authorization. It was supposed to go away in 2018, and it didn't. There have been a lot of lobbying efforts to try to keep the H-4 EAD around. But two things to kind of note on this. The first thing is if you have H-1B employees, you should be prepared for a lot of stress and anxiety and frustration if the H-4 EAD goes away, because for a lot of our employees, you know, the income that these H-4s are generating supplements the income for the household. It's a way that the spouse can work. So having that work authorization stripped is something that, you know, is not going to go unnoticed. The second thing to keep in mind is if you have H-4 employees, so employees that are working under this H-4 EAD, it's probably time to start considering sponsoring them. Most of these H-4s are qualified for an H-1B or are qualified for another sort of visa. Given that the H-4 EAD is kind of up in the air, it's something that we should all be considering. The second thing that I wanted to talk to you about are changes to the H-1B lottery process. There's been a lot of buzz around this lately. I can't give you a tremendous amount of detail because we don't have a tremendous amount of detail yet. But basically, USCIS is planning for this upcoming year to include a registration where basically H-1B employers would register their candidates online prior to the submission of the hard filing. There's a lot of concern about, one, I mean, no one knows what this is going to look like. And two, no one really thinks that immigration has a system that's well-tuned enough to be able to handle 200,000 registrations. But, you know, we'll see. So stay tuned on that. And then finally, lots of chatter regarding the U.S. Department of Homeland Security moving money and resources around to continue their strong immigration enforcement measures. In the healthcare industry, this will probably look like I-9 audits, F1 STEM OPT audits, ICE showing up to detain immigrants, and other sorts of incidences of DHS showing up at your doorstep. Kelly?
Yeah, I'll add on the worksite enforcement context that a lot of the issues we've been seeing too are with staffing companies. So to the extent you're an organization that uses a staffing company and you don't know if that's in your suspect that that staffing company might have workers that are not authorized to work because of something they said, or you don't have any assurances in your contract with that staffing company that they have gone through the I-9 process with their workers. That has been sort of a target of immigration lately, and I expect that to happen in the future as well under the sort of umbrella of worksite enforcement.
Absolutely. So again, these issues, if and when they do come up, not insurmountable, but we just want to make sure that you all are in the know as to what we're hearing on this end, and then, you know, being prepared that there's nothing else better than that. So with that, I'm going to stop being bad news bears and hand it over to Kelly for closing comments.
Yeah, so as Christine said, it's all about the preparation, right? The idea here is that we want to make sure that you're prepared, and a lot of these issues where you might have just filed a visa petition for an employee and never really thought about it, sort of the compliance issues or the timing of it, there are some just additional considerations because of these policy changes that we've been seeing that just make it a little bit more there's a little bit more thought that has to go into these cases than there have been before. And there's a little bit more preparation because you have to think about what happens if ICE comes on site and how to handle that. So before we wrap up, I just want to make a quick correction on your slide titled, Who is Eligible? Thank you to those of you who pointed out the typo. It says for the new California law, it's the first state to provide health benefits to young, low-income, undocumented immigrants through the state's Medicaid program. That's a typo, so I'll get that fixed. But just thank you to those who pointed that out. If you do have any other questions, please send them our way. Christine and I are happy to chat with you about issues. We'd love to hear your questions, your experiences, so please do submit those. We do want to thank you for joining us for our program today. We hope that this information was helpful to you and your organization. If you haven't already, we do ask that you click on the survey icon at the bottom of your screen to complete our short survey, because your feedback assists us in providing quality future programs. And on that end, if you have ideas or topics that you'd like Christine and I to talk about, or our immigration team to talk about in the future, let us know. We're interested, and we've got several thoughts about future webinars, and we'd like to hear your input. As a reminder, this program has been approved for continuing legal education credit in Illinois, Iowa, Missouri, Nebraska, Tennessee, and Texas, with Wisconsin credit pending. The program's also approved for HRCI and SHRM credit, and then a recording of the webcast will be available for tomorrow for watching and sharing. Once that link is available to the recording, it'll be emailed to you along with a certificate of attendance. This concludes our webinar for today. Thank you very much for joining us.